Hey guys, this is Steven with Foxtrot Family Law. Going to do an answer on AVO. We've already talked about AVO, what it is, where it is, avvo.com. Go there, check out lawyer profiles, different fields of law, answers and questions, legal guides. So let's take a look at a question that I love that this person asked this question because it is one of those simple little issues that is just near and dear to my heart because it's something that the general non-lawyering, non-child custody experienced public completely misunderstands. So let's get into it and see what we have to say. This is a question on ABO. My children's mother isn't complying with court-ordered visitation. She blocked me on FB and blocked my phone number. Okay, yeah, that's bad. We're going to dig into that a little bit too, but here's the specific question. How many police reports would I need to get of her not letting me see my kids so the judge would grant me full custody of my children? Okay, the key that I love about this is this person is saying, how many police reports do I need? And the answer is real simple. 0. Goose egg. Because a police report isn't evidence of anything. It's a record. You can make your own records of missed visitations. You don't, and honestly, I hate to say it this way, but law enforcement, they don't want to deal with child custody issues. I know how important this is to us, to our firm, to what we do every day, to what you guys do, committed parents and caring relatives in child custody cases. But law enforcement, police officers do not want to get into these kinds of situations. I mean, they'll fill you out a report, but that doesn't mean they're going to do anything about it. And technically speaking, there is a crime called interference with custody. It's a felony, which means the DA's office has prosecutorial discretion, and they don't prosecute it. They allow the civil system, the family courts to work this stuff out. And honestly, you guys should too. What this person needs to do is make their own contemporaneous records. Hey, I showed up Friday night at 6 p.m. I was where I was supposed to be, when I was supposed to be there, and the other side didn't show up. That happened this time, that happened the time after that, and it happened the time after that. Now, by this point, hopefully even maybe by the first or second time, you are speaking with an experienced child custody lawyer and considering filing a civil claim for contempt of court for violation of the court-ordered schedule. Throw in the lack of good faith communication on Facebook and blocking the phone number. I am a fan of communicating in writing, but that's, text message, email, maybe even Facebook message, or maybe Our Family Wizard or something like that. Some way to communicate in writing. So being blocked, that's bad too. But the key here, guys, do not run down to your local police station and file a police report. If you're supposed to meet at McDonald's and you want to buy a Coke, so there's some sort of time-stamped record of you being where you're supposed to be, when you're supposed to be there, that's fine. If you, in fact, do meet at the police station, I mean, honestly, I'd still prefer that you just write it down, just keep it in your calendar. We were here, they didn't show, that sucks, and they're in contempt, and you can bring that up with the court. I understand that the motivation to file a police report, it feels like you're doing something. It feels like there's some record of it, some official record of it, even though your record's just as good as the police's record because they're only going off of what you say anyway. It's also free, whereas you would have to go invest financially in the services of a lawyer in order to get to do, something regarding civil contempt. But honestly, you kind of get what you pay for as far as these police reports are concerned because, they make a record of it and nothing happens, guys. I mean, as long as I've been doing this, now you guys, if you want to leave a comment about how filing a police report helped you out, I'd love to hear about it. You would teach me something. But honestly, it's a waste of your time and energy. The police don't want to do anything about it. They don't want to deal with it. And you're spinning your wheels when honestly, you need to notify the courts through proper pleadings, through proper representation, that visitation is not happening the way it's supposed to. And someone's inability to support that relationship between you and your child may be grounds for a modification. There's some law out there that says contempt by itself is not grounds for a modification. It's just contempt. It's grounds for contempt. But at some point, you are harming the child, or the other side is harming the child by interfering with that relationship. So, yeah, I think this person has a good opportunity to bring some important things to the court's attention. But the number of police reports, I don't accept the premise of the question. Police reports are 99% of the time a waste of time and energy regarding non-compliance with visitation. If there's some other exigent danger, like if your child is missing, you have reason to believe that they're under some threat of harm or danger, that's completely different. That's not what this question's about. That's not what I'm talking about. Then contact law enforcement, absolutely. But if it's just, hey, I missed my visitation and I don't like it, and I get to file a police report for free rather than pay a lawyer to actually get something done about it, then you kind of get, like I said, get what you pay for. So my advice to this person: don't worry about the police report. Make good internal records at the time. That's called a contemporaneous recollection or recorded recollection, made at the time something is happening. That's going to give it more credibility. So if you're keeping your calendar, you're keeping a journal of issues like this as you go along, that's going to help you be effective in your case. But until you lawyer up and bring it to the attention of the family courts, it is very unlikely anything's going to get done. So this is sort of a boots on the ground thing. You're in a position to do some good, but until you pull the trigger and go about it the right way through the civil court system, through the family courts, I wouldn't be optimistic about making any progress with police reports alone. So don't worry about that. The communication issue, yeah, they need to keep lines of communication open. There might be a school event, a medical appointment, something. Y'all need to be able to communicate in writing, and I certainly would bring up that issue as well when you file your claim for civil contempt, which, by the way, in theory, you can ask for a judgment of attorney's fees. Now, real quick before we end this video, how attorney's fees work in family law cases is that most of the time, and especially in this circumstance, the client, somebody has to pay a child custody lawyer up front to bring the contempt claim. And then you can get a judgment against the other person to reimburse you for those fees. It's not like our friends Tommy Sinyard and Tyler Mann getting paid on contingency. It doesn't work like that in the family court system. It's not even allowed to work like that. So you would need to get reimbursed for those fees if the court finds that there were good grounds to bring your petition and the other person is in significant violation of the order. So consider those logistical issues along the way. Don't worry about the police reports. Best of luck to you. Get started ASAP before you miss any more of your visitation, before your child misses another opportunity to spend important time with you. Best of luck.